Probably the easiest way for police to do a search and find incriminating evidence without having to worry about that pesky charter is when you give them consent to search you, or you waive your rights under Section 8. Today on Don't Talk TV, I'm going to look at what's required for valid consent search and talk a little bit about why you should never ever consent to a search. Hello, my name is Nicholas Wansbutter. I'm a criminal defense lawyer in Stratford, Ontario, Canada, and welcome to Don't Talk TV. Consent searches are something that I don't see especially frequently, but I do see it once in a while, and it's certainly something that police frequently try to get. This is because once one's waived their rights, the police don't need to worry about a charter challenge, they don't need to worry about getting a warrant. Trying to convince you to consent to a search makes their jobs way easier than they would be otherwise. There are some very specific requirements that are laid out by the courts for what constitutes a valid consent search. So as you'll see, the police can't exert undue pressure, they can't bully you, that's not consent. And also you just acquiescing to a search, in other words, failing to object to a search, does not equal consent. So a leading case on this is a 1992 decision of the Ontario Court of Appeal titled Her Majesty the Queen and Wills. I'll put the citation and a link in the show description below. I've got the case open to page 25 here, and the court gives a summary. So it indicates here that the situations where it is said that a person has consented to what would otherwise be an unauthorized search or seizure requires that the Crown establish on the balance of probabilities that 1. There was a consent, express or implied. So as I indicated, mere silence does not equal consent, although that implied consent could come up if you step out of the way to let them into your house, or you open up the trunk to your car and gesture in a way to show them they can look in there. 2, the giver of the consent had the authority to give the consent in question, so a visitor to your house doesn't have the authority to consent to your house being searched, for example. 3, the consent was voluntary in the sense that word is used in Goldman above and was not the product of police oppression, coercion, or other external conduct which negated the freedom to choose whether or not to allow the police to pursue the course of conduct requested. So that goes to what I said about the police not being able to bully you or intimidate you or say, if you don't consent, we're going to arrest you. Although I'm not sure that the courts would consider it coercion if they said, if you don't consent, we're going to get a warrant. And the police threatening to get a warrant is absolutely never a reason to consent to a search. Let them get the warrant. But frankly, if they're asking you for consent, they probably know that they don't have enough to get a warrant. And they, in fact, most likely don't have enough to get a warrant. So, again, another reason, don't ever consent to a search because the police say they'll get a warrant. Let them get the warrant, let them get the sniffer dog, whatever. 4, the giver of the consent was aware of the nature of the police conduct to which he or she is being asked to consent. So the police made it clear what the search was going to entail. 4, the giver of the consent was aware of his or her right to refuse to permit the police to engage in the conduct requested. And 6, the giver of the consent was aware of the potential consequences of giving the consent. So in other words, the person giving consent is aware that charges could arise if the police find something illegal in the course of their search. So as you can see, there's definitely some clear requirements placed on police. But, as always, I recommend don't count on defense counsel bailing you out of an ill-advised consent to search. My advice is never, ever consent to the police conducting a search. Because you don't know what they're actually looking for, you don't know what they're really investigating. It's just, frankly, never a good idea. And with the proliferation of laws that we have nowadays, it's not inconceivable that you could be committing a crime without even knowing it, or possessing something that you're not allowed to possess without knowing it. Or the police may disagree with your interpretation of the law of whether you're allowed to have something. There's just simply never any upside to consenting to a search, with plenty of potential downsides. It's like your right to silence. It's there for a reason, and I therefore recommend you do not waive that right. Don't waive Section 7, your right to silence. Don't waive Section 8, your right to be free from an unlawful search or seizure. And as always, contact a lawyer if you need advice. This episode is not legal advice, so call a lawyer. You can call another lawyer, or you can call myself. My 1-855 number and website are listed below, and we can give you advice tailored to the specific circumstances of your case. If there's any other topics you'd like to see me cover, please leave a comment in the comments section below or send me an email. And if you found this video interesting and informative, please consider liking, sharing, and subscribing, and following me on social media.